This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Supreme Court has handed Arizona Republicans a partial victory. In a 5-4 decision, the court is allowing Arizona to require proof of citizenship to register to vote using the form provided by the state for state elections. However, the court refused to allow Arizona to require voters to provide proof of citizenship when they register using a standard federal form to vote for president or by mail. 4 justices, liberal Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson, and conservative Amy Coney Barrett, would have rejected all the RNC's requests. Joining me is Rebecca Green, a professor at William & Mary Law School and co-director of the Election Law Program. Rebecca, Arizona handles federal and state elections in an unusual way. Tell us about it.
So the way that elections are run in the United States is largely a matter of state law. So state legislatures make most of the laws that govern elections in the United States, but the federal government, through some provisions in the Constitution, is given the authority to make laws that affect elections. So then they've done that many, many times. So you can think of the Help America Vote Act after Bush versus Gore. You can think about the National Voter Registration Act, which is often called the Motor Voter Act, which Congress passed in 1993. And the authority that Congress derives to pass federal legislation that affects how states administer elections has long been rooted in the Constitution. And those laws are examples of Congress using those powers. So in 2022 in Arizona, there's been a lot of debate in Arizona, to put it lightly, over proof of citizenship requirements. There was a 2013 case where the challenge was essentially whether or not Arizona had to use the federal form for registering voters. The federal form did not have a proof of citizenship requirement. In other words, you didn't have to show or prove with a document that you were a U.S. citizen, but you did have to check a box certifying that you were a citizen under penalty of perjury and criminal sanction. And so the U.S. Supreme Court held that form, that the national law, the federal law requiring use of that federal form or acceptance of that federal form preempted state law. In other words, that Congress had sort of more authority than a state over that particular question, since Congress had spoken and federal law trumps state law. So what's happening here in Arizona more recently is this claim that there's actually a difference between presidential elections and other federal elections, like elections for Congress. And the theory is that the U.S. Constitution, through Article 2 authority, is different than time, place, or manner authority that Congress might have under Article 1, Section 4, so that there's these different provisions that authorize Congress to write laws that affect elections. So the argument, anyway, is that when it comes to selecting presidential electors, state legislatures have exclusive authority, and Congress, through the NVRA, through the motor voter law, doesn't have authority. So basically what Arizona is trying to do is to bifurcate how elections are run, to make it sort of a different set of rules for presidential elections versus other kinds of federal elections and state elections. It's very confusing, but I hope that unpacked it at least a little.
Yeah, so now, from what I understand, an Arizona federal judge blocked the state's proof of citizenship law, and then a Ninth Circuit panel reinstated it, but a different appeals panel blocked it in a 2-1 decision. I mean, what has the response been to Arizona's argument by the federal government?
The briefs in the case, go through all of the kind of settled practice in terms of recognizing the congressional authority to legislate in presidential elections. And they talk about different parts of the Constitution that authorize Congress to do so. So there's just been sort of a pushback, both with respect to how we all understand the process to work and also what authority Congress has in this area, in different areas of the Constitution, like the causes I mentioned, and also its authority under the 14th and 15th Amendments, the necessary and proper clause. There's all kinds of pushback to this idea that state legislatures have exclusive authority to legislate when it comes to presidential elections.
Is this a novel argument in Arizona, or have other states tried this?
I don't believe any other state has tried this, but I know that many other states are sort of on board with this argument. And it's something that Arizona has tried in the past, and other states like Kansas, for example, have, especially with this proof of citizenship question, tried to kind of end run around the federal law by having a different system for the state elections and federal elections in terms of what's required to register to vote. So there's been pushback from states. I wouldn't say a lot, but there's been some states that have pushed back against this idea that federal law controls and set up different systems so that at least for state elections there would be a different process. So this has been a live question for several years now.
So with this decision, did the Supreme Court just sort of split the baby?
So the court did sort of split the baby. I guess that's one way of putting it. But most importantly, the court preserved use of the federal form for presidential elections for Arizona voters. So new voters can still use the federal form to vote in federal elections. And the federal form, the distinction here again is that the federal form only requires that voters essentially check a box affirming under penalty of perjury, which, has criminal sanctions attached to it, that they are, in fact, U.S. citizens. And then voters who use the state form, the court held, can be required to show proof of citizenship to vote in state elections. There had been a bifurcated system of registration already in Arizona, and this opinion doesn't just disrupt that.
What about the Purcell principle that you don't change anything so close to an election?
Yeah, that's why the ruling was surprising in that sense. You'd think that the court would want to keep in place what the lower court did because we're so close to an election, but it did disrupt it slightly, although it kept part of the stay alive. So it will create confusion. In fact, if you read some of the coverage of the decision, there does seem to be quite a bit of confusion about what exactly it means. It's very hard to parse. Of course, it's an unreasoned order, so we don't know what they're thinking. And so, if the court is concerned about confusion, in the lead up to an election, this certainly doesn't seem to help.
Wasn't Justice Kavanaugh the one who talked about the Purcell principle about, not changing things before an election?
Yes, he was, and he was not one of the justices who signed on to the order issued. So we don't, and this is what happens on the shadow docket, is we don't know, even justices who sort of stand behind, the outcome, that we don't know why. So it's all of a mystery at this point.
So as far as on the ground in Arizona, does anything change?
It does mean something changes. So it means that people who want to register to vote in state elections using the state form must provide proof of citizenship in order to do so. And there had been a stay on that previously, and now that stay is lifted, meaning that anyone who uses a state form to register to vote must show proof of citizenship in order to be put on the rolls. I guess people in Arizona are somewhat used to a bifurcated system, but you can imagine people being confused about what the court order means and whether or not they're still registered. And I think there's going to be a lot of people in Arizona sort of waking up and trying to figure out to make sure that they are in fact registered and that they're okay. People who registered using the federal form, there's been no change, so they should be fine. But again, they may be confused, and that's a risk, that you run into when you're making changes or ruling this close to an election.
Do you think that this opens the floodgates to other Republican states or groups who want to challenge election rules so close to the election?
I really don't think so. I think that we are kind of in the last phases of this election season, and I don't expect that courts, particularly federal courts, are going to want to rock the boat now that people have started registering, now that ballots will be printed soon. I think we're getting into the zone where I think courts are going to be extremely worried about causing confusion among voters and election officials.
The Republicans are always pushing the proof of citizenship requirement. Why is that?
Yeah, so I think it's in response to the kind of concern that non-citizens are voting in large numbers, which, of course, has not been documented to be a widespread problem. There's no evidence of that happening. And, it's also, I think people can understand that, if you're an undocumented immigrant, there's a lot on the line if you go and, fraudulently register to vote in terms of your ability to ultimately gain citizenship. So it would be a huge risk. And the idea that a huge number of people are doing that is pretty hard to square with the reality that you're really putting yourself in the crosshairs in terms of getting, deported or in trouble criminally for registering to vote if you're not a citizen. So it's not a problem that's been documented, and you can understand why it wouldn't be happening on a large scale, because people would really be jeopardizing their status. They did so, not to mention facing criminal sanctions. So that said, I think the immigration issue is a really hot political issue, and, I think that people who are circulating these theories are trying to gain some traction politically by doing so.
Usually before an election, there's a lot of litigation over election rules, etc. Has that happened this cycle?
Yes, of course, it absolutely has. And just, I think people might be concerned that there'd be a lot of challenges to state rules, both from Democrats and Republicans. But I think it's important to remember that that's a feature of our system, not a bug. In other words, anybody can challenge the way our elections are run, and the court will hear it, and that's kind of how the system works. And the idea is that gets kind of worked out far in advance of elections so that the rules are in place, and any concerns that somebody would have about the rules would, have open opportunity for people to challenge and a court to hear those concerns well in advance of an election. So that by the time you get to the election, the rules are in place and people feel confident that they're constitutional and otherwise administrable and correct.
Thanks so much for being on the show, Rebecca. That's Professor Rebecca Green of William & Mary Law School. Coming up next on the Bloomberg Law Show, Republican states are suing the Biden administration over its new program giving a path to citizenship to immigrants without legal status married to U.S. citizens. I'm June Grasso, and you're listening to Bloomberg. Texas and 15 other Republican-led states are suing to end a federal program that could potentially give nearly 500,000 immigrants without legal status who are married to U.S. citizens a pathway to citizenship. President Joe Biden had announced the program in June.
For those wives or husbands and their children who have lived in America for a decade or more but are undocumented, this action will allow them to file the paperwork for legal status in the United States. Allow them to work while they remain with their families in the United States.
The states suing to stop the program say that the administration bypassed Congress to create a pathway to citizenship for, quote, blatant political purposes. Joining me is immigration law expert Leon Fresco, a partner at Holland Knight. Leon, we've discussed this before, but remind us what this program is about.
It's called the Implementation of Keeping Families Together program, or it's also known as the PIP, the Parole in Place program. It's a program that the Biden administration put in at the same time that it put in its executive order closing the border to balance that out by saying that in addition to that provision, there would be a provision that would be more compassionate that would say that people who are married to United States citizens but who cannot obtain legal status because they crossed the border of the United States unlawfully, those individuals will now be able to get legal status because the thing that was banning them, which was that their admission was not done legally, will be cured by this parole in place, which will basically say, we will now admit you, but we won't make you actually come to the border and re-enter legally. We'll just give you a parole, which is a sort of a permission slip that says, as of this moment, you've entered the United States legally, so now you can go ahead and petition for a green card or lawful permanent residence, as it is known, because of your marriage to a U.S. citizen.
So Texas and 16 Republican-led states are suing to end the program. What's their main legal attack?
Well, they have a lot of different theories about why this is not a legal program. But basically, it comes down to a couple of main ones, which is that at the end of the day, they say that the parole program that the Biden administration has put in is suffering from two main legal defects. The first is that the very concept of parole in place, although it's been used in the past, and it was used mostly for the undocumented spouses of people in the military, so nobody cared because people didn't like the idea that a person in the military could have their spouse deported. So people generally thought that was fine and didn't sue at the time. But now they're sort of saying, look, we should revisit this concept of can you actually be given a parole if you're already inside the United States? So that's their first argument, is that that concept in and of itself is illegal. That what a parole is it's a permission for someone who's at the border, who's outside of the country, who's trying to enter. It's a permission to allow them to enter. but it's not a document that you can get once you're inside the United States. So that's their first argument. Their second argument is that in 1996, Congress dramatically limited the parole authority to a case-by-case basis and upon an urgent humanitarian circumstance. And they're saying that neither of those two things applies here because this isn't a case-by-case basis. This is a programmatic change where even though the administration is saying, look, there's discretion to deny this on a case-by-case basis and all decisions shall be made on a case-by-case basis, they're saying there's sort of this wink-wink understanding if you meet the criteria for the program, you are going to get it. And so they say that violates the case-by-case requirement because this is not case-by-case, it's programmatic. And secondly, they're saying that, look, even if this was case-by-case, you can only grant parole for urgent humanitarian reasons or for a significant public benefit. That's the two words that are in the statute. One is urgent humanitarian reason. Second is significant public benefit. And they're saying that neither actually exists here because all this is an end run around what Congress wanted, which was Congress didn't want people who crossed the border without authorization to be able to gain legal status in any way. They wanted them to have to leave and have to redo it from the outside. And so they're saying it can never be an urgent humanitarian reason or a significant public benefit to have a parole program whose goal is to circumvent the Congress's statute.
The Republicans who are attacking it say it's essentially a form of amnesty for people who broke the law. I mean, Biden is giving special privileges to people because they happen to be married to U.S. citizens, whereas other people who are here who crossed illegally as well and who've been here for the same amount of time and who haven't violated the laws, et cetera, aren't given this. So it does seem a little bit unfair to me.
Well, it is correct to say that, whatever word you want to use, amnesty or some other word, it is correct to say that people who are currently in an unlawful status will, if this program survives these court cases, be allowed to enter not only into just a lawful status, but ultimately to lawful permanent residency and ultimately, even after that, potentially U.S. citizenship if this program is allowed to continue so long as they were married to U.S. citizens. And it is true that all of this is sort of being made up on the fly in the sense that this requirement that you had to have been in the country for 10 years, none of this is based on anything. It's just based on the way they wanted to define the program, which is that you have to have been here for 10 years and you have to be married to a U.S. citizen. And you're correct. There's other things you could be that could be more compelling or less compelling, but they didn't choose either of those. This is the concept that they chose. And one would say, well, why did they choose this? Well, one is because there's an actual U.S. citizen who sort of has skin in the game here, and that there would be harm to that U.S. citizen if they lose their spouse due to deportation. But secondly, there is this concept that was already in place in its entirety, but the only difference was the only people who could take advantage of it were spouses of people in the military. So now it will be spouses of all U.S. citizens as opposed to just spouses of people in the military.
Yeah, and the Republicans also say that, this is close to the election. It's blatant. The Biden administration is playing politics here. I mean, has this idea ever come up before?
Sure. When the military parole program was announced, this was the fear of a lot of Republicans. They said one day somebody's going to try to expand this to all U.S. citizen spouses. And they will say, because we didn't object to it at the time when we did it for the military, that we lost our right to object to this. And lo and behold, some of those people who did criticize the program at the time have been proven right, that ended up happening, that this program did get expanded. But it is also true that no one filed a lawsuit or objected to the military parole program at the time, other than some of the people who do this professionally for a living who don't want any programs of this kind, of any kind, done. They did say this would happen, and so now it has happened. So from the extent of has this been considered, the idea was, yes, it was considered from the day that the military program was announced over a decade ago, that would be the potential outcome of this, as they would try to do all spouses at some point. But was this done as an election item? Well, certainly it was done very close to the election. It was done at the same time that the border was closed, to appease people who were criticizing that the border was closed. And so there's not an immunity to those criticisms because one could point to those facts and say this was done for political reasons. In any case, the question is what happens now, and I think the administration is taking these applications, and I think both immigration lawyers and the clients going through this need to be very careful and need to decide, is this something that I want to do, where if this gets enjoined or if the administration changes, and now I've put my name forward and I've exposed myself as someone who's here illegally, and I've given my address and I've given all my biographical information, I can be found immediately. Is that something people think is wise to do? So I don't know how many people you're going to see applying for this before the election, as opposed to perhaps the idea being that the U.S. citizens who would benefit from this would vote for this, knowing that the election is going to be the difference as to whether this policy or this program actually becomes a program that actually gets implemented in its entirety. And also perhaps the relatives of these U.S. citizens may have some sympathy for the plight of the U.S. citizens. So to that extent, it is potentially a useful political move, but a political move nonetheless.
They estimate that about 500,000 people could be eligible. Factor that in. So what do you think? How strong are the Republican states' arguments against this program?
Well, I think there's a lot of very interesting arguments. And the arguments about the way you read the statute are now going to be viewed along the lines of no deference to the administration any longer, as we now know. And so the question is, does the statute, when you have a plain reading of it, permit this type of parole in place? And that's ultimately going to come down to one judge in Texas. Well, first there will be the standing question, and the standing question will be very interesting because the most likely way that the states will lose here is in the standing question, which they've lost recently in other lawsuits, because the argument would be, why would it be a problem to take people who are here unlawfully and make them legal? What harm does this do to the state? And the state is saying, well, 5 years from now, we may need to give benefits to these people when they're eligible for benefits. But interestingly, there's a thing in the law called an affidavit of support, which says that if you're sponsoring someone for a marriage-based green card, you actually have to prevent them from getting benefits, meaning you have to pay for whatever it is they need under the law. So it actually will be very interesting to see on standing if the state loses. That's the most likely way the states will lose. But if they can survive the standing issue, then the question is going to be, will a judge, first in Texas, then the Fifth Circuit, then the Supreme Court, decide by looking at this statute, just the plain language without any deference, two things. Is parole something you can actually do inside the United States? It'll be hard to make that argument. I don't know a very clear statutory reference that says you can grant parole already inside the United States, as opposed to that's something that's happening at the border. Now, that problem theoretically can be fixed by making everyone in this program just check in at the border and come back. So that would sort of be a Pyrrhic victory for the state if they ended up winning that, but fair enough. But then the second one that I think they more want to win on is that there isn't a significant public benefit or an urgent humanitarian reason for doing this. And I think that's where the rubber is going to meet the road, and that's literally just going to be the opinion of the judges, because if there's no deference, then the judges have to decide, is this an urgent humanitarian reason or a significant public benefit, or isn't it? And I think that's going to be a very interesting question, which will just be in the eye of the beholder.
And the beholder will be a Texas judge and then the very conservative Fifth Circuit. This goes to my next question. They're asking for an injunction to stop the applications, et cetera, while the lawsuit plays out. Is it likely that a Texas judge will give them an injunction? I'm not sure which judge is in charge of this case.
Well, I think the judge that got assigned was in the Eastern District of Texas may, in fact, grant the injunction. But the point is going to be, about standing, really, at the end of the day, because I think these judges are sympathetic in the Eastern District of Texas to the arguments that are being made by the state of Texas. But I think the issue is just going to be, can they survive this question of standing? Where is the harm that they're going to be able to show here? And if they lose on standing, then no, they won't get the injunction. But I do think if they can get past the standing, then I think in general that will mean the court is sympathetic toward wanting to end this program and will then enjoin the program. They'll have to go all the way to the Supreme Court probably, because the Fifth Circuit will probably maintain that injunction, and they'll have to go to the Supreme Court to try to get a stay. And the question is, will they be able to get such a stay? I don't know. Sometimes the Supreme Court in these recent cases hasn't allowed the stay. They've kept the injunction in place. And then only when the case finally works its way up to the Supreme Court do they end up making a decision that supports what the Biden administration wanted.
To get in this program, they have to pay a $580 fee, fill out a long questionnaire, an explanation of why they deserve humanitarian parole, and supporting documents about how long they've been in the country. There hasn't been anybody who's been assessed at this point. I mean, does it sound like it's more than just a rubber stamp?
Well, I think the question is going to be whether this really is going to be done on a case-by-case discretionary basis. And I do think some people will be denied, because people are always denied. People were denied for DACA, the program that was done for undocumented children, the Deferred Action Program. There were children that were denied for DACA who met the criteria of the program but were still denied as a matter of discretion. And usually that might be because someone had an arrest or they had something problematic in their background or something of that effect. So not everyone is going to get in, but the question is, if it's 98%, 99%, is that still a programmatic program, or is it still a case-by-case determination? Now, the court won't have the benefit of that analysis here, but they may have it from other programs that can be looked at that were also deemed to be case-by-case applications, such as the Cuban, Haitian, Nicaragua, Venezuelan program that was done, and that was to parole people from outside the United States, and also DACA, so that the state of Texas can say to the judges, every time they say they're doing these case-by-case determinations, they're still approving high 90 percentile applications, so are these really case-by-case determinations? That will, again, be in the eye of the beholder, of the judge, to determine based on their individual assessment of that definition.
Texas has been busing migrants to New York for some months. Texas has apparently stopped busing migrants to New York.
Yes.
Why?
What happens is that at the moment, there seems to be a hold in place that's been happening as a result of this Biden administration closing the border. It's been very interesting because you've had the ACLU not actually ask for a preliminary injunction to get rid of that policy. There actually appears to be a détente there, where they're taking the slow road and basically letting the Biden administration get through the election. And so the combination of that asylum ban and the combination of Mexico enforcing its border and the combination of Panama also enforcing, not letting people get from South America into Panama, all of that accumulation has really reduced the number of people appearing at the southern border to try to cross illegally. And so because of that, there just aren't enough people for the Abbott administration in Texas to actually put on buses and send to other places.
Thanks so much, Leon. That's Leon Fresco of Holland Knight. Coming up next, some unusual aspects of the JLo Ben Affleck divorce. This is Bloomberg.
You're saying that you're feeling lonely, but you messed up, baby, I'm sorry. I'm doing so much better without you.
It's just a song and no indication of how Jennifer Lopez is feeling after filing for divorce from Ben Affleck exactly 2 years after they were married. The couple famously split in 2003, calling off their first engagement. Both went their separate ways, got married, had kids, got divorced, and almost 20 years later found their way back to each other. But now Lopez has filed for divorce. Joining me is celebrity divorce lawyer Christopher Melcher, a partner at Walzer Melcher Yoda. Chris, this is her fourth marriage, his second marriage. I haven't read anything about a prenup. Would you be surprised if there wasn't a prenup?
It's highly unlikely that this couple got married without a premarital agreement. They've been married before. They've had other relationships. They're both wealthy with kids of prior relationships that need to be protected for inheritance rights. So it would be improbable in my mind that they got married without a premarital agreement.
According to things that I've read, tabloid and others, they pre-planned the terms of the split, and he had moved out of the house in something like May, and they put the mansion on the market in June. So she filed pro per without a lawyer. That seems unusual. Is it unusual?
It's really unusual. There's no way in my mind that she did this without the assistance of a lawyer. She just chose not to list the name of that lawyer on the paperwork. I think this was probably for image purposes, to make it look like this would not be a fight, that it's going to be just processed as an agreed-upon divorce. So I think that's the message she's trying to send with the, no lawyer listed on the paperwork. Most of these cases are resolved before they file in court, and that's the smartest way to go because they can maintain their privacy and they can do it quietly, agree on all the terms. The only reason why she needed to file for divorce in that instance is to get their marriage terminated, because the judge has to be the one who ends the marriage, and they can only do that with an active case. So that's probably what we're seeing is a fully documented and agreed upon settlement of all financial issues. It's already been signed by them, and now she just needed to file this case to ask the judge to terminate their marital status.
She listed the date of separation as April 26th. Why is that significant?
In California, we have a partnership model for marriage. So any property that either spouse acquired from the date of marriage to the date of separation is community property and is shared 50-50. So when the spouses stop living together with the intention of ending the marriage and one spouse has communicated, hey, we're done, then they're legally separated. That terminates or ends this marital partnership. So that's why it's important to know the date of marriage and the date of separation to understand what assets or streams of income were acquired or earned during that period.
And as far as we know, the mansion in Beverly Hills worth something like $60 million is the main asset that was acquired after they were married.
They did acquire this really expensive property in Beverly Hills during their marriage, so that would be community property unless they had a premarital agreement or other side agreement that made it different, like equally separate or owned in separate proportions to each other. The down payment that was made on the house, if it came from, like, for example, Jennifer's premarital property, then by law she would be credited with that and get reimbursed off the top for the down payment, and only the appreciation would be split with Ben, again, unless they had some other kind of arrangement. The problem, though, is that this house was not owned for very long, and it might have increased in value a bit, but it's very expensive to sell a home. There's not only the real estate commissions, but in Los Angeles we have a mansion tax. So if the house exceeds $5 million, there's quite expensive taxes that are levied on that property. So this would likely result in a loss to the couple.
So she asked for no spousal support, and she asked that Affleck not get any either. I mean, with, very rich people who go into marriage later, who have children from separate marriages, I mean, is there normally a lot of fighting or controversy in the divorce, or is it easier?
Well, it should be easier to solve these problems between two wealthy couples, but it's all relative. It doesn't matter how much money somebody has. They never want to give it to their former spouse or partner. And there's a lot of resentment or resistance to sharing after a marriage or relationship is broken up. Now here, either one of these has no need for support. They're extraordinarily wealthy. There's no need for support from one or the other. So that wasn't going to be really an issue. But in other cases in California, when one spouse has all the money and the other is left really without any assets, there's going to be substantial spousal support to maintain that spouse at the marital standard of living.
She requested a new name on their filing. She got some criticism for changing her name when she got married. Nowadays, do most women keep their own name or change their name?
Well, certainly things have evolved over time with regard to women taking their husband's surname. But here, she has the right to have her maiden name restored. So she has checked that box on her divorce petition, which is common. And so when the wife chooses to take her husband's surname, sometimes they'll maintain that surname, married name, if they have children together, because it's just whatever reason seems to be more convenient or less confusing for the mom to maintain her married name when they have kids together. But when there's no children, many times we will see a request to restore the maiden name.
She filed for the divorce. Is it just how it looks? Is there any advantage for one party to file rather than the other?
There's a slight legal advantage to being the first to file because they can maintain the initiative over the case as the petitioner. They get to go first if there's a trial. But most of these cases are not litigated. They're mostly all settled. So the decision on who the petitioner will be sometimes is left up to a coin flip if the couple's really getting along, and because there can only be one petitioner and then the other is automatically the respondent. So sometimes they'll just flip a coin to figure out who's going to be the person to file first. Other times there's a lot of messaging and thought around it, which I would suspect is going on here, where it was important for Jennifer to be the one who took the lead and said, I am filing for divorce. I want this divorce. Maybe Ben had said, hey, if you want a divorce, fine. I'm not going to fight you, but I'm not going to be the one asking for it. So there's a lot of dynamics that are involved with that relationship that will dictate who's going to be the one to file first.
And speaking of appearances, she filed on the second anniversary of their Georgia wedding and hours before the Obamas spoke at the convention. I take it hours before the Obamas spoke because she hoped somehow that this wouldn't be noticed. How could that be? But is there any message or anything about filing on the second anniversary?
I got to think that there's some reason why she filed the day she did, because there was no urgency to it. So some spouses need to file immediately to get protection, financial protection or protection against abuse, and that'll drive the filing date. Here, there was no reason for her to file on that date other than to send some kind of message that, this was 2 years, a second anniversary, or what I think more cynically is that she picked a date that would also involve a lot of media attention to try to detract from it. Now, and that did bear out true, although the story got quite a bit of attention. On the day that it was filed, there were a lot of reporters who were engaged with the Democratic National Convention. And so that did detract at least some of the initial attention away from the case.
And are prenups still for the rich, or are they more for people who have blended families? Where do you see the most prenups, or is it just across the board?
I mean, we see a lot of people asking for prenups that maybe don't need them. Certainly, I think that they're indicated when a spouse or prospective spouse has children from a prior relationship, because there's rights of inheritance that need to be preserved for those children of the prior marriage, let's say. And it's just a really horrible thing to put the child adverse now to this step-parent that's coming on scene. And so the way I look at it is that prospective spouse with the kids has prior obligations to those children and also now taking on new obligations to the spouse. So a prenup is a really nice way of balancing those things, and I think is appropriate. The other time is when we have somebody with extraordinary wealth and complex finances that need to be protected and also just make it easy to sort out in the event of a breakup. That is fine in my mind to have a premarital agreement, but not a one-sided you get nothing and like it deal, which is oftentimes what's proposed. And sure, that's most protective, but it's also detrimental, I think, to the relationship because it creates a power imbalance and resentment there where one spouse has everything and the other spouse has nothing. And to think that party, that unmoneyed party, is going to be happy in that situation is just really unrealistic.
Thanks so much for joining me, Chris. That's celebrity divorce attorney Christopher Melcher. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.